Court Watch with Alex Swoyer, and I'm excited to bring you the latest episode of my podcast, where I am joined by Nathan Lewin, a Supreme Court lawyer who has more than 50 years of experience litigating at the High Court. He filed a brief in support of Maryland parents who argue their religious rights are being trampled by the Montgomery County Board of Education, which is not allowing parents to opt their children out of LGBTQ-related story time as early as preschool. The conflict arose when the Montgomery County Board of Education in Maryland decided not to let elementary-age kids opt out of reading storybooks on gender transitioning, pride parades, and other LGBTQ issues. While high school-age students can opt out, elementary-age and children as young as 3 cannot. The school board in the fall of 2022 rolled out the school curriculum that celebrates pronouns, pride parades, and gender transitioning, including the Inclusivity Reading Program for students from pre-kindergarten through 5th grade. At the time, parents were given notice and they could opt their children out. But in 2023, the school system reversed its policy and said it would no longer notify parents in advance about readings. A group of parents from different faiths, Muslim, Catholic, Protestant, and Jewish, argue that the school board was infringing on their free exercise of religion since there is no option to opt their children out of that story time. The lower courts rejected the parents' request for an injunction, prompting the appeal. Thank you so much for joining my podcast today. I saw that you had filed a brief in support of the Maryland parents in the case of Mahmoud versus Taylor, which I believe it's argued this coming Tuesday, April 22nd. So I found your position interesting, given that you had filed a brief supporting Amish parents and their request not to be forced to send their children to school past 8th grade over their religious beliefs under Wisconsin law. That's such a landmark precedent. And I guess that Wisconsin law, correct me if I'm wrong, but I think it wanted to keep kids in school until they were 16. So that 1972 decision with Wisconsin v. Yoder giving the parents a win, I was hoping you could give me a little bit of historical perspective on the importance of Yoder precedent and how it applies to this current case with Mahmoud versus Taylor before the justices.
Well, the unique view of the brief that I filed back in the 1972 case was that I argued not so much as parties are arguing today in terms of the burden on parents, but I said that the First Amendment's free exercise clause requires government to accommodate to religious observance. Mm-hmm. I presented that perspective not only in the Yoder case, in which I was filed one of very few amicus briefs. In this case, that's now pending and is going to be argued on Tuesday, I think, as I counted up, there were a total of about 61 briefs filed. When I filed a brief in Yoder, there was only a handful of amicus briefs. And as I say in the very beginning of my amicus brief, having been a law clerk in the Supreme Court in 1961-62, I know that in those days, my boss, Justice Harlan, read all the amicus briefs. He would take them home. Mm-hmm. Today, it's impossible for a justice to read all the briefs that have been filed in a case. If 61 briefs have been filed, as was true now in the Mahmoud case, no justice has read or will have read 61 briefs at the time of the argument. So it's very different today than it was then.
Yeah. I know the holding from Yoder seems to be exactly what you were arguing, that the free exercise of religion under the First Amendment outweighs any state interest in forcing parents to send their kids to school past, a certain time, I guess, according to their religion, which was 8th grade. The law at issue was, I think, 16 years old. So if that's the precedent, which seems pretty strong precedent, why is, why is this an issue we're dealing with now when it comes to talking about something like, LGBTQ reading for kids? Some of these books they're presented to pre-K age, with Wisconsin v. Yoder precedent that this, how did we get here with a lower court, I guess, not just looking to Yoder?
Well, what's happened is in all the years since 1973, the court has made various limitations and restrictions on the Yoder holding. Justice Scalia, who was a classmate of mine, by the way, at the Harvard Law School and a lifelong friend, wrote in his famous Argonne versus Smith opinion that Yoder was a case in which it was not free exercise alone that was an issue, but parents' rights as well. And in other cases, since Yoder was decided, Yoder has been watered down so that today, as I said, the briefs seem to think that the important issue is how much of a burden has been put on parents. And under current constitutional tests, that's the issue. To me, the free exercise clause, the language and the directive is Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And the question is really, has government essentially prohibited the free exercise? And my view is that the First Amendment requires affirmatively that the government accommodate to individuals' exercise of religion and is not really to be tested by how much of a burden is imposed on the person who's exercising his or her religion.
You said that you were a friend of the late Justice Scalia. Where do you think he would be on this issue?
I think, really in terms of his personal views, he would probably believe that parents should have the right to keep their children who are in public school from being exposed to lessons or books or reading material that offends their religious sensibilities. But I think he, if one takes his language in Argonne versus Smith at face value, would say that's only because they are parents. And parents, according to him, have particular rights in addition to the free exercise rights.
Let me ask you, with the current makeup of the court, do you suspect that they will be open to the Maryland parents' claims here, sympathetic to them? And is there any certain justice or justices that you are focusing on during oral arguments?
Well, I think that a majority of court, since the court did take the case, will agree with the parents. And given the court's current attitude towards religious freedom, will recognize that under these circumstances, the parents have a right to demand that their children be excused from these classes. I think that's going to be a majority of the court. I think the, quote, liberal minority will very likely or very possibly dissent. Although it's possible that because of the parental interest, they may also agree that this is a circumstance under which the parents' religious freedom and sensibilities would prevail.
Right. I've covered the court since 2017, and it has been very pro-religious liberty. in the recent years. And so I agree with you. I think that the fact that they took the case, it signals that there's at least 4 votes that think the lower court, got it wrong. And so I guess, signaling they'd be sympathetic to the Maryland parents. I guess, if my guess is wrong and the justices were somehow to rule against the parents, I guess my question for you is what type of precedents in terms of both, you talk about parental rights and religious liberty, would be threatened? How, are we talking about other major cases that would be undermined by something like that? Overruled or
think if they were to reject the parents' free exercise of religion claim, that would conflict with some of the more recent pro-religious exercise decisions that they've issued, which recognize that the Constitution gives rights to religious believers. I mean, in my brief, very short, maybe the shortest of the amicus briefs, I went through a history of the cases that I was involved in which, during the time that followed Yoder, the court emphasized the Establishment Clause and rejected various religious rights. Even though we amended the Civil Rights Act, they undercut it with language in their opinion. Then they've come back again to recognize that religious observers were granted statutory rights by an amendment that I had drafted and that Congress passed for the Civil Rights Act. So, we've seen over the years the court emphasizing the Establishment Clause and now turning back and emphasizing the Free Exercise Clause again.
Right. And that should bode well for the parents in this case specifically.
Absolutely,
right.
Yes. It's an indication that the current court would uphold the rights of the parents in this case, which is, I think it's a very minimal limitation on states' rights or state authority and to prescribe curricula in public schools.
Right.
They may prescribe it, but they have to accommodate, and that's my key phrase. They have to accommodate to the beliefs of the parents.
Yeah, and I mean, I think also the more people hear, and maybe it might come up during arguments, just from not necessarily a legal perspective, but a common sense perspective, that some of the books that were being read, I think I did a report previously about this case, and there's a book called Pride Puppy. It tells 3 and 4-year-old students to find images from a vocabulary list. It lists drag queen, underwear, leather. There's another book, Born Ready, the true story of a boy named Penelope, that talks about the child knows best about gender transitioning. I think that, away from even just talking about the law, it just seems kind of, I think, to a lot of people, common sense that why does a 3 and 4-year-old need to have, why is this the reading, and why wouldn't parents have a say?
Sure. Many years ago, when I was of that age, and then even when my daughters were of that age, I would have thought it was ridiculous to really subject them, to require them to read books with that content. Apart from being offended, I would never have thought that it was part of a good
curriculum.
Education,
Exactly.
Primary school education, to include these kinds of material.
Yeah, I have a 3-year-old, and I have to tell you what, I would be making sure that she would not be participating.
Yeah.
It just seems kind of head scratching where there's any sort of, I guess, educational value in that, especially for that age group. Thank you so much for taking time to join the podcast. Since this is such a late argument, do you expect this to be one of the rulings that we get at the end of June when the justices are wrapping up the term?
Yes, I do expect it will be decided close to the last days. I mean, during the years that I was arguing a number of cases in the Supreme Court, in those days, the court would meet to decide cases on Mondays, and we would know kind of when the term was ending that there were a huge number of decisions that would be coming down at that point. Now the court is no longer limited to a decision Monday, but I remember when I argued a case involving the right to have a Hanukkah menorah as part of Pittsburgh City Hall holiday display, it was the last day of the term into July when the court decided that case among maybe a dozen or more than a dozen others.
Wow.
So the end of the term, the court, I recall, even when I was clerking, it would be a wild time because draft opinions would be circulated among the justices, and there would have to be quick decisions or proposals to change the language of the opinion. And that's what happens at the end of the term. And I think this case will be one that will be decided close to the last day of the term.
Well, we're all anxious to hear and see how arguments go and what the justices do. I really appreciate your time this morning. Thank you so much for chatting with me.
Thank you very much.
Of course. Thank you. Thanks for tuning in to the latest episode of Court Watch. If you have not subscribed yet to this podcast, please do so, and also feel free to email me interesting questions or topics that you want explored about the legal reporting world. I'll do my best to answer them during each episode. Thanks for listening, and I look forward to hearing from you all soon. Listen to my podcast, Court Watch, at WashingtonTimes.com or wherever you get your favorite podcasts.